as we reach the summer, as cases are rising, it looks like you want to be kind of refreshed on the particulars of these issues, and there are some updated guidance and some changes as we move into the summer. First step you want to figure out with any of this is which of these COVID-19 sick leave laws apply to you. You're only, any business entity is only going to be covered by one of them. So the Family First Coronavirus Response Act is a federal one. It applies to employers with under 500 employees, but it covers all such employees, and it has 6 qualifying reasons, which we'll get into, and it's set to last through the rest of the calendar year. If you don't qualify under the FFCRA, you may qualify under the California Supplemental Sick Leave, which was an executive order from Governor Newsom. It is for employers with 500 or more employees, but it doesn't apply to all employees. It only applies to food service workers, which we'll clarify. It has 3 qualifying reasons, and it is set to stay in effect for as long as the California stay-at-home order is in effect. And then there are some localities have local sick leave, which may apply if you aren't covered by any of the others. Specifically, the city of Los Angeles has a supplemental sick leave order, which applies to employers that have over 500 employees in Los Angeles or over 2,000 nationally, so large employers. But we'll focus on the federal and the state, which I think applies to most people on the webinar. So starting with the FFCRA, it has 2 components. The first component is an emergency paid sick leave, which available to all employees of a covered employer. It applies for 80 hours of paid leave for your full-time workers. Part-time workers, they get whatever their number of hours would be over a 2-week period. If they have a variable schedule, then you kind of have to do a little bit of math over the previous 6 months. But that's how much you can get under the paid sick leave. How can an employee use it? There's 6 reasons. 1, if they're subject to a quarantine or isolation order related to COVID-19. 2, if they're advised by a healthcare provider to self-quarantine due to COVID-19 concerns. 3, if they're experiencing symptoms of COVID-19 and they're seeking a medical diagnosis. I think the interplay of that is while they're waiting to get diagnosed for COVID-19, they would apply under this reason number 3. And then if they test positive, they would potentially move into reason number 1 or 2. Additionally, number 4 is if they're caring for a person who's subject to number 1 or number 2, they can get leave under that reason. Number 5 is if they're caring for a son or daughter whose school or place of care has closed due to COVID-19. And then 6 is the kind of a catch-all for additional conditions, which I haven't seen any specified, so I don't know if there's any conditions that qualify. But those are the reasons, and it's critical that the employee has to be unable to work or telework because of one of these 6 reasons to qualify for this paid sick leave.
Now, Mike, before this second pause here we had in California, when this law first came out, there was a lot of confusion if these orders that, that certain industries had to shut down, for example, restaurants couldn't offer dine and eating, and if the restaurant closed, would that trigger the FFCRA and that analysis?
Yeah. It's a great question. No, it wouldn't. It's specific to the employee. So if the business is forced to close because of some order, that doesn't qualify the employees to take leave. We get a lot of questions. Well, if I'm forced to close because of the Governor Newsom orders it, do my employees qualify for this leave? Under the federal leave, no. Potentially under the state leave, but I think it's pretty clear under the federal leave, no, it doesn't. It has to be that the employer has work available for the employee, but the employee is unable to work because of one of these reasons.
Yep.
Great question.
Good.
So if they do qualify for one of those 6 reasons, how much do they get paid? If it's one of the first 3 reasons, it's their regular rate of pay with a cap of $511 a day, a total cap of $5,100. If it's reasons 4, 5, or 6, then it's 2/3 of their regular rate of pay, with a daily cap of $200 and a total cap of $2,000.
Sorry, I'm posting some stuff on the chat here too, so I'm a little behind on the slides.
Important record keeping. What information do you need from your employees when they request this FFCRA leave? Critical to understand, you need to record this information whenever they request it, regardless of whether you grant it or if you deny the leave for whatever reason. You still need to collect this information. You need to record the name of the employee, the date that the leave is requested, the reason for the leave, and the certification from the employee that they're unable to work because of one of these reasons. We'll add a big caveat. Under the FFCRA, you can get tax credit to reimburse for these payments. So talk to your accountant. There may be, and probably is, additional information that you would need to fill out the forms to apply for these credits. But we're focusing specifically on what information do you need to get from the employee. Additionally, if the reason is that they are staying home because of an order or they're caring for an individual who has a quarantine or isolation order, you'll need to get the name of the government entity that issued the order, and preferably, probably, you would recommend get a copy of the order as well for your records. If they're staying home because they've been advised by a medical professional to self-quarantine, or they're caring for someone who's been advised to self-quarantine, you'd also want to get the name of the healthcare provider. And again, check with your accountant. There may be additional tax documents that you need, but that's what you need for the employment side. So as you know, this passed in the spring when there was still school going on. We had some question, well, what's going to happen when the schools would normally get out? And we've gotten a little bit more clarity from the government. They've indicated that summer schools and camps and related kind of organizations and activities do qualify as places of care. Now, most of them were never opened in the first place because of the coronavirus, but it's been clarified that those can still qualify for employees if their child was actually or planned to enroll before the camp closed. And so they'll need to provide evidence that they had planned to it, that they had enrolled, or that they had planned to enroll, to substantiate that this was actually something that was going to happen. That can include an application or a deposit or any kind of evidence that if their child had used it in the last 2 years, something to substantiate that this was going to be a source of their child care and it's now unavailable. As we discussed, if the employee is furloughed due to lack of work, for example, if the business closes, that doesn't qualify the employee for FFCRA leave. And critically, if the workplace is forced to close, if you have an employee who's already on leave, that kind of extinguishes the leave. So the employee can get paid for leave that they used before the closure, but as of the closure, the employee is no longer for FFCRA leave, even if they're currently already on it. We sometimes hear questions. Well, I've had employees who have been teleworking for weeks or months now, and then all of a sudden they come up and say now they need this leave because they have a child care issue. Is there any kind of that if you hadn't used it before you're ineligible for? The government said no, they remain eligible to use the leave at any time. It doesn't matter that they were teleworking fine beforehand. They don't have to show any kind of changed circumstances. As long as they can show that they're eligible for a reason that would qualify for the leave, they can use the leave. There's no limitation. Then there's also as we mentioned, if you have 500 or more employees, you may have qualification under the state's supplemental paid sick leave. It doesn't apply to all employees, though. It applies only to food service workers, which are employees who are covered under one of these 4 wage orders, 3, 8, 13, or 14, which are agricultural related. Or if the hire entity operates a food facility or the worker delivers food from a food facility. In that case, they would get full-time employees would get 80 hours of paid leave, and then part-time employees would get the regular number of hours of leave over a 2-week period. Again, if they have a variable schedule, there's a little more math involved. Now, the reasons that you can use as California sick leave is if the worker is subject to a federal, state, or local quarantine or isolation order. So again, the number one reason from the FFCRA, or if the worker is advised by a healthcare provider to self-quarantine, which mirrors issue number 2. What's different here is the third reason is if the worker is prohibited from working by the employer due to health concerns related to the potential transmission of COVID-19. That can also be a qualifying reason. It's one you don't see in the FFCRA. It potentially applies and arguably applies to situations where if you have a restaurant that you had to close because there was a positive case, the other workers are, I think, can properly be classified as being prohibited from working, and so they may qualify for leave during the time that the restaurant is closed. Also, if you send an employee home because maybe they won't pass a screening or you have some other concern COVID-19 related, that can qualify under that third reason, which is different from what you would see under the FFCRA.